Going through a divorce is a major life event. Understanding the divorce process in Florida can help reduce stress, uncertainty, and costly mistakes. In this video, I'll walk you through the key steps involved in a Florida divorce. While every case is different, this overview will help you understand what to expect from start to finish. Before a divorce case can be filed in Florida, at least one spouse must have lived in the state for a minimum of 6 months before filing the petition. This residency requirement must be proven using a Florida driver's license or state ID issued at least 6 months before filing, Florida voter registration, or testimony or an affidavit from a third party confirming residency. Without meeting this requirement, the court does not have jurisdiction to grant a divorce. The divorce process officially begins when one spouse, called the petitioner, files a petition for divorce in the circuit court, family division, in the county where either spouse resides. Florida is a no-fault divorce state. The legal grounds for divorce are the marriage is irretrievably broken or the mental incapacity of one spouse, which requires additional statutory proof. Most Florida divorces proceed under the irretrievably broken standard. After the petition is filed, the other spouse, known as the respondent, must be formally served with a copy of the petition and a court-issued summons. In Florida, service of process is typically completed by the sheriff's office or a certified private process server. Service must occur within 120 days of filing unless the court grants an extension for good cause. Proper service is essential because it formally brings the respondent under the court's authority. Once served, the respondent has 20 days to file a written answer with the court. In the response, the respondent may agree that the marriage is irretrievably broken, disagree with certain allegations, request relief regarding property division, support, parenting, or time-sharing. If no response is filed within 20 days, the petitioner may seek a default. However, even in default cases, Florida courts must still hold an evidentiary hearing before issuing orders related to children or financial support. Because divorce cases can take months or sometimes longer, either spouse may request temporary relief, also called pendant light relief. Temporary orders may address temporary alimony, temporary child support, attorney's fees and costs, exclusive use and possession of the marital home, temporary parental responsibility, and time-sharing. These issues are governed by Florida Statute Section 61.071 and are intended to maintain stability while the divorce is pending. For safety concerns, Florida does not use generic restraining orders. Instead, parties may seek interpersonal injunctions, such as domestic violence or dating violence injunctions, under Chapters 741 and 784 of the Florida statutes. Florida has strict mandatory disclosure requirements under Family Law Rule of Procedure 12.285. Within 45 days of service, both spouses must exchange specific financial documents, including tax returns, bank statements, pay stubs, credit card statements, financial affidavits. In any divorce involving child support, a Child Support Guidelines worksheet must be filed and cannot be waived. In addition to mandatory disclosure, spouses may use formal discovery tools such as interrogatories, requests for production of documents, depositions. Florida courts strongly encourage and often require mediation in contested divorce cases. Mediation allows spouses to attempt to resolve issues such as property division, alimony, parenting plans, and time-sharing and child support. Mediation may be waived in cases involving documented domestic violence where mediation would be unsafe or inappropriate. If mediation is successful, the agreement is written into a marital settlement agreement, which must be signed by both spouses and approved by the court. Florida law no longer uses the terms custody or visitation. Instead, divorce cases involving children focus on parental responsibility and time-sharing. As of 2023, Florida law creates a rebuttable presumption that equal 50-50 time-sharing is in the best interest of the child, unless evidence shows otherwise. A detailed parenting plan is required in every divorce involving minor children and must address time-sharing schedules, school designation, decision-making authority, communication, and transportation arrangements. If the spouses cannot resolve all issues, the unresolved matters proceed to a final hearing or trial. In some circuits, cases may be referred to a general magistrate for evidentiary hearings, but this requires the consent of both parties. At the conclusion of the case, the court enters a final judgment of divorce, which must include specific written findings on alimony, including need and ability to pay, child support calculations, parenting and time-sharing determinations, equitable distribution of marital assets and debts. Florida requires a 20-day waiting period after filing before a final judgment can be entered, unless an answer was filed prior to the waiting period deadline. Though in practice, most contested divorces take significantly longer than 20 days to resolve. Even after a divorce is finalized, post-judgment issues may arise. Modifying support orders is governed by Florida Statute Section 61.14, and modifying parenting plans is governed by Florida Statute Section 61.13. Enforcement depends on the type of order. Support obligations and specific acts may be enforced through contempt, and property division is enforced as a creditor-debtor matter, not through contempt. Divorce in Florida involves many legal steps, especially when children or significant assets are involved. Understanding your rights, responsibilities, and options can help you avoid costly mistakes and move forward with confidence. Speaking with an experienced Florida family law attorney early in the divorce process can make a meaningful difference in the outcome of your case. If you have questions about your specific situation, contact a qualified Florida family law attorney to discuss your options. To reach out to Nest Law, visit nestlaw.com.